Welcome. I'm Steve Parrish. I'm the co-director of the New York Life Center for Retirement Income at the American College. And as always, I thank you for signing in. I wanted to start up by just saying I was surprised earlier this month when I was watching TV and they aired this local news headline from the 11 o'clock anchor. And she said, estate planning is more important after COVID. Why you don't want to do this alone. On tonight's 11 o'clock news. It just caught me off guard because who knew that estate planning would be a bigger headline for the local news than local heroes saves cat and tree. So it's an interesting topic, and I'm assuming that this audience knows that estate planners all over the country are being slammed with business. After the devastation of the pandemic, people want to get their financial affairs in order. So today, what we want to do is discuss estate planning, but in the context of three issues: how estate planning issues apply when doing financial or retirement planning as part of the comprehensive planning, how to deal with the topic due to the disruption of COVID-19, and how to deal with the potential seismic changes that may be coming with taxes. So we have a great panel to discuss these issues. Sophia Duffy, Sophia and I, well, frankly, you can blame her for hiring me. But to her credit, she's done some great work on financial tech issues, particularly artificial intelligence. So it's nice to have you here, Sophia. And Mark and I have taught together, and we share a common interest in music, the difference being that he actually has talent as a guitarist. And finally, we have Jim Karthaus. We need to be nice to Jim. In addition to him being a financial planner for 20 years, he's a retired Lieutenant Colonel Marine aviator. So we don't want to make him mad. And thank you for your service, Jim. So welcome, panel. And let me tell the audience, the common link that the four of us have is we're the four professors who teach HS 330, which is the estate planning course for CFP and for CHFC. So as I mentioned, as you can imagine, we've had a lot of Teams meetings where we've discussed what are we going to do with all these things that are so uncertain? Okay, so before we get into talking to the panel, I'll do a little talking here just to set it up, and then we get to the questions. But let's talk about the 1,000-pound gorilla that's in the room, and that's the prospect of increased taxes. So I thought I'd just take a few minutes, and then we'll turn it over to the questions just to kind of think through this. So I'm sure your clients are slamming you with these questions about, well, what about these proposed taxes? What planning changes should I make? And it's tough to answer it because we don't know. But here might be an analogy you could draw. One that occurs to me as a way of saying it is you think about traffic signals, and you have green light, go, you have red light, stop, and yellow light, caution, okay? Well, you might think of maybe the one green light where it looks like it's barreling towards being passed. You never know till it is, but is the Secure Act 2.0. And so that one's one where maybe from a planning standpoint with your clients, you actually can start talking about it. We don't know, but I mean, it has gone through the House and it's working its way through the Senate. Then you have kind of the red light ones, the outliers, the ones that I just don't think Congress is going anywhere with. An example would be Senator Warren's wealth tax. Or on the flip side, some of you may have heard in some of the farm states that a bipartisan group of senators have proposed cutting the estate tax rate in half. Well, I just don't see that happening with a Democratic president. But then you have the ones that are basically in that cautious zone. And that's the ones we're all thinking about and wondering questions about. So just to go through real quickly, if you kind of summarize this at the 10,000-foot level, they're talking about bringing rates from 37% up to 39.6, which was what it was in the Obama era. A big one is they're talking about capital gains over $1 million being raised all the way up to the 39.5%. And you include in the NII tax, and you're talking like 43% tax. That's big. Then you got, as far as estate planning, the big issue of what do you do with the basis of assets at death? You know, they've been stepping up forever, and now they're talking about having a carryover of basis. And there's really two things going on. They're also talking about actually, like Canada does, charging the tax at the point of death. So you basically have that capital gains hit at death. But it's interesting to notice that Representative O'Neill, who runs the Ways and Means Committee, has already started kind of hinting at, well, maybe not actually taxing at death, but just having the carryover of basis. And then when you sell the asset later, it becomes taxable. So we'll see. Other caution signs in the area of estate and gift tax increases, that's very fuzzy. We know that Senator Sanders has talked about a $1 million gift exemption and a $3.5 million estate tax exemption and a top rate of 65%. But we know there's a lot of wiggle room in there for negotiation. I think the interesting issue is there are a lot of specific proposals for the strategies we use in estate and gift tax planning, like curtailing grants, taking away grantor trust, intentionally defective grantor trusts, removing a lot of the discounting you can do for closely held businesses. And so I can see one scenario where a lot of these things like the exemption and the rate are negotiated back closer to where they are now, but these strategies become part of the tax bill and they kind of just slip through. So that's something we'll have to keep an eye on because it affects estate planning. And then the one other caution is just down the road stuff, I think. We know that the Tax Cuts and Jobs Act, if Congress does nothing, what happens is the estate tax exemption is cut in half in 2026. And then Social Security, candidate Biden had talked about this Social Security tax. We don't know where it goes, and it may not be part of what happens this year, but because of the deficit in Social Security and because that's such an important part of people's retirement planning, it's going to come up at some point. And so, I just think we've got to be seeing something coming up here pretty soon. Okay, so that was my quick intro. Let's go to the panel. Are you all awake? You're back? Okay, good.
Everything, yes.
Nice lunch. Good. All right. So, Jim, let me start with you. So we got this reality check of the fact that, all right, so we have what, 592,000 deaths from COVID. And in the estate planning area, we've had the challenge of patients who have been rushed into isolated wards and hospitals where their agents under the medical power of attorney have no access to the patient or to the doctor. And for close to a year, advisors have been unable to work directly with clients. I've seen wills signed on car hoods and taxes handled by a drop box at the advisor's office door. So Jim, you've been living through this. How have you seen clients' attitudes change regarding estate planning issues, especially if it's part of their retirement and financial planning during this pandemic?
Steve, it's interesting you mention a reality check. I don't know that we have a shared reality around us. It seems as if 1/3 of us were crushed by this. 1/3 of us kind of, neither here nor there. We retained our jobs. Maybe we took a little out of our 401k, over half the population did. And another 1/3 of us are getting in shape buying properties. So I don't know if there is a shared reality around it. And I think that's going to evolve. I'm a historian at heart, along with those deaths, which are absolutely tragic, particularly the way they happened. So at a distance, loved ones couldn't get near their loved ones. The emotional impact of this thing, when we really kind of clear out, it's going to be significant. But there's also some issues, maybe from an estate planning, maybe more on the attorney side, and I'll defer to the august counsel here. 32 million of us got COVID. 1/3 of us, which I'm proud to be part of that, 1/3 of us had some neurological impact within 6 months. How does that manifest down the road? How does that manifest for doing documents down the road? Should we be meeting with clients fast? So sooner rather than later. So I think the reality, it's just so incredible how this thing panned out. At first, we thought it was going to come to get all of us. Then it only really came to get a few pieces of the economy. The economy jumped back. The market went down. Then it popped up. We didn't have any sports betting, so everybody jumped in the market and bought cryptocurrency or GameStop. It really is a tough place to get a litmus on. And I think and add to that on either side, the political polarization. And it's kind of, I'm not telling you anything, we're all living this, we all see it. But in terms as an advisor, trying to get your firm footing, I think it's going to bring us back to just now that we can start meeting with our clients, get back to meeting with them and finding out, not financially necessarily how they're doing. We want to know that. We need to know that. And we've probably been talking about them via Zoom or some other web meeting software. but how are they feeling? How are they really feeling? This is a seminal event in our lives. For some of us, it is the seminal event in our lives. Estate planning is about feeling more than maybe anything else. How do you feel about your own mortality? My hope, Steve, and I'll wrap it up with this, is that clients don't have a heightened sense of their mortality to the extent that they lose sight of retirement. I worry about retirement. Year over year, your labor statistic just came out at 4.2%. I don't care in the short term. I don't necessarily know if that's a blip or not. Better minds than mine are at it. I care about 6 business cycles. What's inflation going to look like? So that's my worry, is that somehow this thing, and understandably so, has given a greater sense of mortality and may take people's eye on off the retirement ball.
Interesting point. We'll be talking about mortality a little more, but let's shift over to retirement. And Mark, a reality is we do have the Secure Act. It's been in full gear. We have these new IRS longevity tables that are effective for RMDs beginning next year. And, Secure Act 2.0 may be coming in through Congress. So from a planning standpoint, how has Secure Act and related changes altered things in estate planning, the estate planning part of financial planning, particularly when we're talking to clients that expect to have some IRAs to pass on to their heirs?
Well, it's interesting. It's not quite headline first thing on the news interesting like you talked about. And in fact, here in my neck of the woods, the lead story is always about whether Aaron Rodgers is coming back to the Packers. So that's never bumped by anything. But if you look at these exact things you're talking about, Secure Act, Secure 2.0, new longevity tables, they all seem to say that, retirement planning and funding your retirement is good, but passing assets on to the next generation is not so good. So even within the Secure Act, there's some good news for retirees to the extent they want to keep deferring. The RMDs are pushed back, that type of thing. You can make contributions after age 70 and a half if you're working still, that type of thing. So those are all saying, yeah, defer more. But then when you look at the kind of headline Secure Act things, it's like, well, that stretchability has kind of gone away. So when you talk about what's the impact on these things on estate planning, well, most people start estate planning by figuring out if their retirement planning is going to work. Because oftentimes estate planning involves giving away assets, and you're not going to give away assets until you know you have enough. So some of the things like Secure Act and Secure 2.0 kind of is doing the same thing. It's pushing the RMD back. It's allowing you to load up more if you're, in that catch-up area, like 10,000 as opposed to 6.5. So it's helping people who are retiring, which then may help them determine, I want to do some estate planning. So it's almost like a numbers exercise for those, because, the difference between 70 and a half and 72 may not be a big deal so far as 1 year tax deferral, but I still want to see how that's going to impact my plan. It just may mean I'll draw from those assets later than a more favorable bucket I might take from sooner, although some people feel that's one you want to take sooner. So for them, it's just a matter of how does this impact my personal retirement planning. But if I've been relying on benefiting my heirs through an IRA, that's where there's some real issues. And one of the first things you're going to want to do is say, well, is there something that I've already done that this is kind of maybe not messed up, but required some adjustment? So in many cases, people may have named a trust as the beneficiary. If you do that right, you can have a trust be the beneficiary of an IRA. You'll look to the age of the oldest beneficiary so far as RMDs. Well, now we have this 10-year period under the Secure Act, which means, well, does that still work as effectively when it's going to a trust than I had presumed based on the old rules? Because those trusts can take 2 forms. One might be an accumulation trust where, the money's going to pour in from the IRA over time based on whatever the RMD requirements are. And then I'm going to kind of dribble it out to beneficiaries as I deem appropriate. And by I mean the grantor from the grave through the terms that were put into the trust. Other times it might just be a conduit where when money comes in from an IRA into the trust, it goes out to the beneficiaries. Well, now if we have this 10-year kind of rule where this has to come out faster, and I notice you passed on the whole publication 590B issue, so let's not even talk about that. But the first thing to look at is if I've named a trust as beneficiary for my IRA, how does that impact the fact that scheme of taking, and by scheme, I mean method of taking assets out of the IRA, how does that play based on the dispositive terms of the trust? A second thing that people will look at is, well, I might have actually been planning on having that IRA be a source of lifetime income for my beneficiaries, because maybe they're not as good with money, and the fact that they're going to get a set income level, that's a good thing. That's kind of a built-in plan in and of itself. Well, now if they can take it all out in 10 years, if I'm looking to the next generation, are there other things I could do to set them up potentially with some lifetime income? And then that's where people will look to life insurance, annuities, again, having more of an accumulation trust where there's a lifetime income aspect. And the third thing I think that people looking at Secure 2.0, longevity tables, is are there other uses for my qualified plan / IRA money than what I had already planned, because of the fact that the taxes are just going to be sped up. So that's taken a little bit of the utility away from this vehicle. Maybe this is something now that I'm thinking, this would be a good asset to give to charity or to leave to a charitable remainder trust, because it's always had some great benefits, but as more of the tax benefits chip away, and again, it's getting chipped away because the deferral isn't as long as I thought, maybe that would be a good asset to, think a little differently about, assuming, again, through my overall planning, I realize I have enough to live on, and there's other assets I might pass on to my heirs.
Helpful. Thanks. Well, Sophia, I've been holding off on the tough question. You get the tough one. And that's these proposed changes to state tax and income tax. So what do you think? I mean, as far as where this is going, is this a seismic shift? Is it the great unknown, or is it business as usual? I know it's not the last, but where do you think this is?
In a sense, it almost is business as usual, because exemptions are changing all the time, right? I mean, the last one just happened a few years ago. But it is a seismic shift because of the magnitude of the changes that are being proposed, particularly for high net worth individuals. Now, we know that even if none of the proposals are passed, the doubled exemption amounts will sunset at the end of 2025. So the planning that we can do, even just to take advantage of the doubled exemption now, is pretty significant for those clients. We know that the IRS has proclaimed that they're not going to have a look back rule for transfers that are made during this time period. So if we make a transfer now, a gift, this exemption will apply, to the extent possible, even if the decedent passes after 2025. So even just to take advantage of that, making irrevocable transfers, perhaps staying away from grantor trust to do that for now until we know what will happen. But even for older clients, maybe considering paying the death taxes at the first spouse death instead of waiting until the second might be something to consider. So as advisors work through some of these proposals, maybe creating some options and then being ready to pull the trigger once the proposals, come closer to being passed might be the best step for now. Now, as far as the actual changes that are being proposed, you mentioned that grantor trusts are being, targeted by both the Sanders plan as well as Van Hollen's plan. The way that they're planning on doing that is a little different. Sanders seems to be gearing more towards estate inclusion in some of these grantor trusts, particularly GRATs. So right now we're making transfers to GRATs and they're excluded from the estate. Sanders is proposing that we may pull some of those transfers back in. So that's something to consider. Are those assets significantly appreciated, in this current time period since they've been transferred? Maybe we want to consider shifting some of those assets out. Van Hollen's proposal is actually taxing the distributions of the trust. So that's a different, a different strategy that we may want to propose. But in both cases, just looking first at what assets are inside the trust and what the tax impact might be is the best first step. And then considering maybe distributing over time as opposed to one big distribution at the termination of the trust. So if we can't escape the tax, maybe just spreading the tax out over time might be a good approach. Now, as far as family businesses, there are limitations on some of the discounts that are being proposed if the business stays in the family. So again, maybe transferring during life as opposed to the business owner retaining that business until death might be good so that the estate is not hit with a big tax bill. Now, Mark mentioned maybe spending down some of our qualified accounts if we can't pass to an eligible designated beneficiary. So if a business is transferred while the business owner is still alive and it's, say, gifted to a family member, perhaps then they can replace that source of income with, for example, an IRA that they couldn't otherwise, stretch because of the Secure Act rules. And then the marital deduction is still going to apply as well. So we can maybe consider transferring some of these assets to a spouse and then waiting to see what happens with some of the tax changes down the line. So, for younger clients, maybe they don't need to do anything at this point. For clients who are not at the high net worth levels, maybe we just wait it out and see what happens. But for, clients who have GRATs, intentionally defective trusts, we want to take a look at those trusts and see perhaps if they may want to be converted or the assets converted to different types of assets.
Okay, that's a lot to chew on. Well, let's shift over to it from a practice standpoint. Jim, most consumers who live beyond paycheck to paycheck seek out financial advice from people like you. And but your world has certainly been rocked by the acronym police. I call them the DOL, the SEC, BI, NAIC, all those things. How have these rules that affect how advisors deliver advice and products, how's that affected how advisors are working with clients? I mean, particularly considering that estate planning is often kind of a subset of the overall financial planning process. So how's that work?
Yeah, it's a good question, Steve. There's been, and there's over time, a long period of time, a movement to get advisors more qualified in what they do, and even to differentiate between a financial planner, an advisor, financial professional. And it's interesting, DOL failed in the courts. I think that was 2018. It may be resurrected, but along came Regulation BI and by the SEC in June 30, 2020. And it's got a two-part piece to that. The first part is to define what is an advisor and who is a financial professional. And Sophia can help me on this and keep me straight and narrow. And that is something we've always been trying to get after, to move beyond just simply introducing yourself as a financial planner when really you don't have the qualifications, or you're really not going to act as one. And so that's one piece of it. How do we figure out whether an advisor is a fiduciary? An advisor will be in a fiduciary. How do we kind of sift through that? So that's one of the things from Regulation BI, which really looks a lot like DOL. DOL would have addressed more of ERISA and the fruits of ERISA. And again, it may still come back. So now from a regulatory perspective, what we have to do as advisors, well, first and foremost, do what you've always done. Be a professional. All these statutes do is basically memorialize the way we've always conducted our business as professionals. And you don't have to have a designation or an advanced degree to act in a moral capacity. On the other hand, you can't legislate morality, and nobody has the high ground with regard to morality, whether it's a fee-based person only or fee only, or somebody who takes a commission. One could make the argument that, well, if you life insurance products are regulated, right? They're filed, can't change commissions on that. You don't have a choice on that as long as you're acting, obviously, prudently and in the client's best interest. On the other hand, fee-based folks, or us who charge a fee, we can change fees, right? We have that discretion. So that might be a conflict of interest too. So the point simply is if we continue to act as professionals, none of these, to your question, none of these regulations are going to do more than kind of put a little bump in the road. And it's funny, as I've gotten older, my college-age kids will tell me I've gotten softer, which is true. I'm more the cat than the tiger, although I don't think I ever was a tiger. But the point simply is I like more disclosure. I like the in the front for Regulation BI is a Form CRS. We're going to disclose to the client exactly how we're going to interact with them. That clears up all sorts of things. And if you think about it, when we engage with clients, it's going to be an account opening from a broker-dealer perspective or RIA, or when we offer advice. So we have to be clear as when we're offering advice. Account opening is fairly straightforward. We have to give the information, the Form CRS, to the client. But when you think about it, when we first engage with the client, it usually is the first time we capture both signatures on the same document. I know I'm going to warm all of my colleagues or attorneys. That's going to warm your heart. It warms mine too. So that, particularly when estate planning, working with older clients, we have clearly identified what we're going to do, how we're going to do it, what kind of recommendation we're making. And this might not be quite as near and dear to your hearts. More is more. Less is not more here, because we're not talking about liability. We're talking about clearly identifying what we're going to do for the client, why we made the recommendations, and we have their signatures. That could be an account opening. That could be in a life insurance application, an annuity application, put more in there. I've learned that over time as a principal to tell folks that. So with regard to what we're looking at, it may evolve. DOL may come back. I give that to my betters. I think it actually is being resurrected. I think it was being resurrected in the last administration, and probably will come back in some form. I like where we're headed as CFPs and CHFCs of the college. We are called to be fiduciaries, so I like that kind of mentality, and I like best interest moving up from suitability. Suitability was good. Best interest is better. And I hope we continue the trend. So yes, it's more onerous paperwork. I get it. Advisors don't like that. But when you think about it, not only are we protecting the client, which is the ultimate good, we're protecting ourselves as well.
Thanks. Well, now that we've established that marine aviators are cats, not tigers, I learned that. Turn it over to Sophia. And Sophia has a lot of background in compliance. And I don't know if you saw the question in there in the chat section about where we are. DOL, but can you add anything to it? And I just want to ask this question because you've been doing so much interesting research and work in the area of fintech. Is that going to be the thing that's really going to save us on the compliance front?
Well, I would say an attorney's favorite answer, which is it depends. And the fintech is such a difficult field to sort of summarize in one aspect, because every impact that technology has on financial services is a new area of regulation. For example, you and I did research on Robo Advisors and the fiduciary duty, as well as the best interest standard. Underwriting, for example, using artificially intelligent underwriting systems is an entirely new area that we've seen. The New York law has actually tried to raise some of those concerns that we have about big data, credibility, discrimination, all of that. That's completely separate then from robo advising. It's completely separate from what Jim mentioned earlier, which is, are e-wills here to stay? As electronic notaries, are they here to stay? So all of those require special regulations. Right now we're sort of retrofitting technology into existing laws. I believe we'll see in 10, 15 years entirely new laws that will come about specific to how technology is used. Now, to the robo question, and can financial technology solve our problems? With the fiduciary standard and best interest standard, we know that robos can actually surpass what we can do as human advisors in some cases, right? We know that they can do portfolio rebalancing because they can continually monitor accounts. They're drawing upon larger volumes of data than a human advisor can. And theoretically, there's no human bias that a robo advisor would provide. But as you and I discovered in our research, there are a lot of issues, right? We know that robos are held to a fiduciary standard and best interest standard, but can they really meet those standards is still up in the air. For example, robos don't have human bias, but they're programmed by financial institutions. And in some cases, they're programmed to maximize fees, right? We know that there's some inherent conflict there. As well as the question, Jim mentioned a really good point, which is elderly clients need the benefit of having a human advisor, because a robo-advisor could never spot, for example, signs of dementia, or if someone is under duress, or if if their health looks like they're failing. Maybe they're sitting down with a client and they see that they're not looking as healthy as they used to. They can ask more probing questions, sort of uncover or unpack what is going on in that individual's life. And that level of protection is not there with a robo-advisor, as well as that, we just can't provide comprehensive advice with at least robo-advisors as they're programmed today, cannot mimic entirely human decision-making processes. So we see that, comprehensive estate plans, retirement plans, those are really best left to a human advisor. So where we ended up in our research, and what I believe is that, the two can be used together, but the robo-advisors alone are a little problematic because of that, fiduciary level standard. And as far as the electronic wills and notaries that Jim mentioned, I just wanted to point out an example. In the state of Pennsylvania, they did actually allow those during COVID, as many states did. And they've said that they are going to continue to allow them, but they've actually input more protections for individuals using those. So for e-signatures, for example, they require additional witnesses to just, so that they have people in the room more than what was required before. And that does raise, from an attorney's standpoint, some challenges. For example, now, let's say previously you could say someone's will had a different signature on it, and that would be, handwriting analysis was traditionally used then to determine if it was a valid will. Well, now we've got technology concerns, right? A level of complexity. You could raise a challenge. Is this software really tamper resistant? Did the software function properly? There's product liability concerns in there now. So it raises the level of challenge and complexity. It doesn't mean they'll be successful, but just advisors and attorneys need to be aware of that from an estate planning context, that we really need to make sure all of these controls are in place to make sure that someone's estate plan is secure.
And let me just ask, because it was in the chat question, do you have any update on what the Department of Labor is doing? I mean, they were looking at really essentially a BI type of standard.
Yeah.
You're doing a rollover, but I don't know where that is right now either.
I don't have any current updates, but we've heard, and you and I found in our research as well, that this sort of march towards a fiduciary standard is continuing. And many states have actually taken the reins on their own. So New Jersey, California, they have all proposed fiduciary standards for all financial professionals, regardless of what they do at the federal level. So it's just wise to be aware that this is sort of a trend that we're seeing. The levels will be, questioned and sort of aligned over the years. Specific to the DOL, though, I have not heard anything significant.
Okay. Well, let's move on to back to where Jim had us with the mortality issues. So we've got this kind of unusual situation going on. We had the IRS extend the life expectancy tables for RMDs. At the same time that overall mortality worsened in the US. I thought this was interesting. According to the Wall Street Journal, for 90 years straight, the US age-adjusted death rate dropped from what it had been 10 years before. So what that's telling you is indicating that we're having long-term improvement in Americans' health. But in 2020, this 10-year measure rose by 82 deaths per 100,000. And obviously due to COVID-19 pandemic, enough to set the US's progress back by nearly 2 decades. That's big. So Sophia, you and I are addressing a national group of estate planners about Social Security in estate planning this fall. I guess we need to figure out what we're going to say. But let me ask you this, between the changes occurring in mortality, the possibility of inflation, which is certainly on the horizon, and the underlying deficit that the Social Security Administration Trust Fund has, where do you see Social Security's future in planning? And since it's hot in the news, also, what are your thoughts on this whole idea of a redesigned Social Security statement?
So the Social Security statement I'll address first. Anything that makes decision-making easier for clients and financial advice easier to understand, I think is a huge benefit. So they've reduced the number of pages in the statement, and they've created a visual representation of what the benefit impact will be at different claiming ages. It still leaves the decision in the hand of the individual, which I think is a plus for the Social Security Administration, but it's an easy format for them to understand. So I do believe that it will help more people make more informed decisions. I'm all for it. Now, as far as the inflation rates, we'll see that there's so much going on with the trust fund right now. We know that there's these predictions that in 2026 it will be depleted, but what that really means is we may see a reduction in the benefit. For affluent clients, that will probably be more of a reduction, right? We'll see that there's a greater impact to affluent clients. So I believe that Social Security payments will still be a core component of their retirement income planning, but it may just take less importance in the overall portfolio of assets. So we may see substitution with other income sources, less reliance on the certainty of the payment amount. Now, with rising inflation, we do know that the payment amounts will increase, but that actually incentivizes people to claim earlier, which is good for the trust fund. So claiming earlier actually helps extend the longevity of the trust fund. So we've got these counterbalancing, impacts. And I wanted to share briefly some other research that I've been doing recently with my colleagues, Michael Finca and David Blanchett, on how the changing demographics for women actually impact claiming decisions. And many advisors really should be aware of, particularly for women that are college educated, that are higher earning, how claiming strategies, and when you're considering, especially with opposite sex couples, how those could be impacted. So in our research, we found that more women are college educated than earlier. In fact, women over 60 are more likely to have a college degree than men. And 30% of opposite sex households have the woman being the primary earner in that couple. So we, with those factors in mind, and we know that women already have increased longevity, both of those factors, college education and higher earning, also increase the longevity of women even longer. So in the research, we noted that by delaying claiming to age 70 or beyond actually extends the benefit for women, again, in opposite sex couples when we're considering joint mortality. What that means, though, is that for women, when they're retiring, we need to find alternative income sources for them, right, for their retirement income. So we consider other assets in the portfolio, and then that will, help us to sort of fill that gap of income. Going back to the trust fund really quickly, an interesting thing that we found is that even with a depletion in the benefit by about 20%, we still find that claiming for women, delaying claiming to age 70 still results in an overall net positive of about $120,000 for women with an average life expectancy. So even if the inflation rates rise, we're still going to see delayed claiming as, you know, a strong strategy for women who are higher earners.
Wow, that's some cutting research. Great. And by the way, I'm aware we have several questions that are really good ones. And if we get time at the end, we'll address them. Otherwise, I usually try to follow up if I you know, I have your emails, and I'll try to do that because I want to ask Jim. I mean, so as we talked about, you know, Social Security is retirement income, but it's also part of the estate planning. How do you work with your clients in talking about Social Security?
Well, I love what Sophia just mentioned with regard to that, particularly with women. The amount of women over 70 who are below the poverty level is distressing. With Social Security is the only asset, which in one sense is good. As a planner perspective, taxes are ephemeral and fleeting. Yes, we know they're certain, but we don't know what they'll look like. With regard to clients' mistrust of it, even if the disability trust fund runs out of 2026 or the survivor trust fund, old age survivor trust fund runs out, it's a pay-as-you-go system. The only retirement system in America is pay-as-you-go, but it's the best one. It's a golden egg paid by the best pensioner, by its own separate tax, by somebody who can print money, cost of living index, and you can't run out of it. No other payment like that, really, except my military pension, but I won't gloat. So the point simply is we want to put it out. If I hear one more, and Sophia, thank you so much, one more thing about the break-even point of Social Security based on a single life, I won't scream. I'll do something a cat does. It's a joint life, mostly always, whether that's two spouses, the federal definition of spouses, and it's a huge decision, insanely impactful. Particularly for the fact that everything we do from an actuary perspective is looking that way. Yes, unfortunately, that blip is something, but the real headline, as you mentioned, Steve, is in the last 100 years, we've doubled life expectancy. That's what people coming back, looking years back over what happened, particularly with the mess that the 20th century was. This one isn't starting out so good, but it's not the 20th century. Point simply is we're going to live long. We're going to live long together as joint life expectancy. Social Security is a golden egg. And from a planning perspective, and I see some of the questions coming in, it's really good. Thank you, Lorena. The planning that I would do is going to be held closely to the vest. And I think Sophia was indicating this, as was Mark. I don't want to go and start doing something irrevocable where I can't get at those assets unless I'm going to orphans court or, doing jumping jacks in front of the trustee to let them know that I really need the money. So I want to do something close to the vest. Social Security gives me that opportunity because it's a flow that I can max out for my clients. I can feel a little bit better maybe deploying those assets. How would I deploy those assets? I would start looking at estate liquidity, but internally held. Sophia mentioned about using the fact that the IRS will not claw back whatever lifetime gifting we use now. As you mentioned, Steve, earlier, estate planners are going berserk trying to, enfranchise that gifting. So I want to do something close to the vest. Maybe I'll hold a policy, buy a life insurance policy, and I'll hold it in my client's name and have the older, sicker client be the owner, maybe have a standby trust, something where I'm kind of doing some estate planning, but I'm not. One, I'm not running a trust for the next 40 years if I don't have to. And two, I can get at the assets in that policy if I need to. So I'm going to start thinking of those kinds of plans. Social Security can help me in that regard. So I want to take a baby step. I'm not bold yet because the joint life expectancy scares me. If you're not planning with a client for age 100, at least, particularly a woman, I think you do yourself a disservice. It reminds me of starting financial planning 20 some odd years ago. And we had this anecdote saying, we're going to plan to your life expectancy at age 87, to which the bane of all financial planners, an engineer stood up and said, "Oh, so you mean I have a 50% chance of my plan failing?" Of course, unfortunately, the answer is yes. I'll be back in a minute. So the point simply is you can't get behind our planning as a planner. You can't be on the opposite side. That's a bad place to be. I show my clients and my students I show them what 60,000 in 1967, and I set them up because, you know, some of us were alive in 1967. 60,000 was a lot of money, but if you were in retirement for 50 years or needed an income stream, by the end of that time frame, you needed 480,000 to replicate what 60,000 would have bought you in 1967. Point simply is we've got to be alive to that and do our planning, as Mark was indicating, to ensure that there is no way we can run out of money. And I'm so worried about that for our clients. Detoxifying the environment. Who knows what pharmacological or medical pieces are, you know, coming. Again, with our best guesses are looking backwards, trying to extrapolate about things we don't even know yet. So anyway, point simply is Social Security, to your question, Steve, is the underpinning for a lot of clients' plans. And I look at it as I don't care how much money they have. It's a golden asset that's a known quantity. Simple kind of 2% maybe move up on payroll taxes, maybe extended taxable wage base can be funded regardless of what the trust funds are going to do. And benefits are not going to be taken away midstream. It's just going to be limited to what comes up. So it is something to worry about. Don't get me wrong. But it still is an underpinning piece for client strategies, and it can help the estate planning piece.
Well put. Next time you should be more passionate about it, but that's a good point.
It's the coffee. I'm sorry.
It's the coffee. Mark, the last mortality question I have is an important client, the business owner. So they've had so many challenges with their businesses, you know, PPP loans and customers and their own families. So again, focusing on some of these mortality and longevity issues, what's likely to change in the business owner's personal estate and retirement planning? I mean, you know, different buy-sell agreements, or are they funding it different? What do you think is going to be happening with the business owner specifically?
Well, you know, prior to the last 18 months, business owners, they're not going to die. They're not going to become disabled, and they're going to die. If they do die, they'll die with their boots on. So you can show me new tables and all this type of stuff, but a lot of business owners are still, you know, maybe thinking that's not a big impact to them. Now, when it comes to actually funding some agreements, well, the fact that life insurance has changed with some new things, or it might be not cheaper, but it might be less expensive for them to do certain forms of funding of buy-sell agreements. But I think besides the mortality and longevity thing going on, all these other potential changes have, you know, we mentioned people taking advantage of the lifetime exemption and giving assets away. Well, if the Von Hollen proposal, that's the one that says, well, yeah, you get taxed at death on the full gain. Well, it also has in there, you get taxed on at a gift. So the fact that that's up in the air, just carryover basis in general, is, I think, a factor that business owners are going to look at. Because if you look at, okay, I'm trying to figure out how to pass on my business, assuming it is going to a family member, there's a number of things that I look at. One is, you know, maintaining control. Another is getting people involved in the business to see if they're going to be able to do it. There's tax issues so far as, you know, the entity that we're talking about, what rates apply to the entity and to the individuals. There's things like step up. There's something where if I give the assets away, there's no step up. Well, wait a minute. What if there is no step up at death either? So a lot of these factors that business owners have to take into account when doing succession planning are kind of up in the air. What I just mentioned, individual rates and entity rates, you know, things like step up. So they're concerned about some of the things out there related to taxes, but they're also, as you said, Steve, first of all, they are business owners. So a lot of them, and this is my opinion, to ask Jim what he thinks as well, that they're still worried about keeping that business going or getting it on track. I mean, a lot of people are coming out of this, and just like Jim mentioned with advisors, there's a third. There's a number of business owners, those 2/3 who either stayed the same or went down, who are trying to build it back. So the fact that all these things are kind of in flux is putting a little bit of damper on planning, especially if you still have a yellow light on some of these Senator Sanders proposals. Those were basically, I didn't see him in any of my webinar classes, but it's almost as though he attended one and saw, oh, this, oh, get rid of that. Oh, you know, oh, annual exclusion gifts to trust, forget it. GRAT, forget it. Grantor trust rules, forget it. It's a lot of these tools that were available they're still there, but they're proposed to be changed. So again, I think mortality, longevity is going to have some impact on the cost of some strategies, perhaps positively, but it's also not as critical, I think, in the business owner's brain when they're looking at their own mortality and plans for passing things on.
It's helpful. And I have one more question before we start looking at the question we've been looking, but at some of the answering the chat ones, and that's Sophia. So here we are, the four professors that deal with estate planning, and you're our guide on this. What's the American College doing considering what's going on with estate planning? I thought that'd be helpful for people to know.
Sure. Well, first to know is that we have estate planning woven throughout so many of our programs. For example, we mentioned CHFC, the Chartered Financial Consultant, CFP, also the wealth management program we have, the CLU, which many of you may be familiar with that from our insurance perspective. It's being broadened and sort of redesigned to encompass risk management in general. And a big planning aspect of that is how life insurance is used with small business owners, estate planning, transferring business from one generation to the next. In addition to our philanthropy program and special needs program. So, it's not a sort of one-stop shop for estate planning. It's all of the programs. And as, the estate planning faculty, we are tasked with, communicating the changes, staying on top of the changes, and then updating that content as well. So we are sort of in full, at full speed right now, trying to stay on top of what's going on and making sure that all of our content is updated throughout all of our programs.
Great. Let's take us to the question section. I'm just going to try to grab some of these. First of all, one I'll answer. Someone asked about New York 187, which didn't just apply in New York. It's essentially a fiduciary or best interest standard for insurance agents. And I wrote 2 chapters of a book on it. So I guess I'll answer that one. It was found unconstitutional. It kind of goes to what Jim said is, okay, yeah, so it happened. But clearly the marching orders are moving towards best interest or fiduciary standard. So it may affect some of the disclosure you do tomorrow, but long-term, I don't think it means much anything, to be honest, as far as the fact. I don't think the compliance departments are going to say, oh, we ducked that bullet. Well, one question that, or a point that was made is some of the costs that we have for retirement are just going to increase as time goes on. So, we were talking about the red, yellow, and green. There's other things that can happen that affect your ability to retire that aren't necessarily proposed outright there, like the IRMA charges that you see from Medicare. As somebody of a certain age who pays those have been going up. And so the IRS could, through Congress, get a lot of money through some things that you're not even necessarily aware of like that. So we just want to mention that. Where's life insurance fit into this? And I don't know who wants to answer this, but obviously a lot's going on, partly because of mortality changes, awareness. How do you see life insurance planning fitting into this? I mean, are ILETs going to be a good idea or a bad idea? Maybe I'll start with Mark on that one.
Well, I'm kind of building on what Jim had said about personally owning life insurance can be a good idea. Actually, having life insurance in an ILET is not that much of a, getting rid of your assets as you might think, because typically the proceeds are what's going to be most useful for the family. And at that point, they'll be accessible because the ILET will either be able to, deal with the estate, or there's going to be an outright distribution. So that's kind of something that I look at that. And I just wrote an article that's kind of saying this, that that's a strategy that no matter what's going on around you, oftentimes that makes a lot of sense. And as exemptions change, whether they go up or down, people look at their existing ILETs and say, well, should I keep funding this? Or should I start a new one? The thing is, it's a type of vehicle that I think has utility in all kinds of environments. And again, if it's designed to help with the next generation specifically, the fact that it's locked away, people might view it that way, but there's many ways to access trust assets. But the fact that it's going to pay off at a time when it's most needed, and there's provisions that allow the trustee to deal with the estate, I think that makes a lot of sense as things are changing even.
And Mark, I'm going to ask you one other question because you referenced it and said I was too chicken to bring up the notice from the IRS. I'll go ahead and mention it since we have a little bit of time. Basically, the IRS came up with a notice when they started talking about how the Secure Act changed to the 10-year rule, where essentially you have to liquidate the account for non-eligible designated beneficiaries. They had an example that made it look like you had to prorate it over 10 years. And our other professor, Ed Slott, kind of went, huh? And the rest of my answer was the IRS was just plain wrong. And that's where it's finally going. So it looks like they're going to clean up their act and just say, well, we didn't mean to say what we said. Mark, did you want to add anything to that since we did have a little time for that?
Well, no, that was something you're talking about, this publication 590-B, that, as you said, with that example, it made it look like, everyone believes, because that's how the law is written, that you have 10 years, unless you're the spouse beneficiary, you have 10 years after the death of the IRA holder to take those assets out. And essentially you could do it at the end of the 10th year. But that publication was implying that, no, you had to do RMDs for those first 9 years. And they've come out and said, yeah, that did not seem to be correct. I'm kind of waiting for Secure Act 2.0 to maybe say, you know what, the kiddie tax, let's go back to the trust rates. But I'm just kidding. That's not what they're going to do. But there's been a few things that have been a little bit unusual. And I think people were shocked when that publication came out, but it kind of dusted up and then settled down.
Yeah. Okay. Well, Jim, how do you see advisors dealing with these challenges in the near future? I'm just thinking short term, as this is all great and we're sitting here doing our professorial things, but when the client comes in, what challenges are you dealing with short term?
Well, just speaking to the life insurance thing, real quick, and I'll answer your question, Steve. With regard to life insurance, I would want a multi-purpose. We know that life insurance has long-term care riders. If you use that, any long-term care insurance, we bifurcate estate planning into what we're doing for the client and then what we're doing for the beneficiaries. Make sure it pays to who the client wants and what they may be, or where they may be treated. In other words, most people are treated informally. That means at home with informal caregivers. Most all long-term care insurance policies will not pay that. So just make sure that you align where the client wants from a long-term care perspective, were you to try to purpose your life insurance toward that end. So once again, I probably want to keep my life insurance pretty close unless I have a client who has significant assets, or we go back to 2006, which is what is kind of out there. Where we limit our gifting, as Sophia was indicating earlier, and then our estate tax threshold or exemption is, our credit is so much lower. With regard to, just to wrap up from an advisor perspective, it's obstacle or opportunity. It's a great time, not just to talk to clients about their financial situation. Get inside, may have those conversations and get inside their hearts, see where they're at. Estate planning is a movement of the heart. It really is. Yeah. It's taking care of the end of your life and the end of your spouse's life, and also enfranchising the ones you love with your assets. That is sacred ground. It truly is. And estate planning is unusual in that it gives us the best piece. Let me say this a little bit better. It really gets us a window into the client's hearts to really help them. And by the way, you get to meet the beneficiaries, right? Clients, advisors don't hold assets very well going to the next generation. Why? They never met the kids. Kids have their own advisors. So it's a nice kind of piece, a little selfish to a certain extent, but good. You're a good planner. You need to be enfranchised with them. So my closing would be, have these conversations with your clients. Now we can do them face to face, right? For the most part, we're evolving into that. And talk about these things, get deeper into it. It's a movement of the heart. It's a good place to be.
Well, great way to end it. Sophia and Mark and Jim, thank you so much for this discussion. I feel better, and very much want to thank everybody for attending. And if you have more questions, be sure to look at those links about our designations or to get a hold of us. And again, Sophia, Jim, Mark, thank you so much.